Okay, good morning, everybody. And I think there's somebody from Germany on, so good afternoon to you. Which I saw in the chat, there's a lot of people on from all over the country and outside the country, Canada and at least Germany, which I saw. I'm John Wilkinson. I'm an attorney advisor with Equitas. Equitas is a resource for state and local prosecutors who are combating violent crime, which is every state and local prosecutor. We focus a lot on violence against women crime. So anything related to domestic violence, sexual violence, stalking, human trafficking, anything related to violence against women or gender-based violence. But we address or respond to all crimes of violence and try and assist state and local prosecutors, and frankly, anyone else who reaches out to us. We don't just work with prosecutors, we work with police, advocates, medical, mental health, judges, and anybody who's engaged in this work. And today, myself and my colleague, Jane Anderson, are going to talk about witness intimidation and some of the things we see and some of the strategies from the prosecution perspective, how we can respond. Equitas, as I mentioned, we're a resource. We have a lot of information. Please check out our website. You can see webinars that we've done, other publications. Prosecutors or anyone can reach out to us via email or call us if they want to talk over a case. We're happy to do that. I think we have 7 former prosecutors on our staff, all with backgrounds prosecuting violent crime cases. We do a lot of training, and so we're happy to be here with National Center for Victims of Crime and CNA. Thank you for having us. And we partner with a lot of folks, including some of the other presenters on this topic, but other organizations as well. You can follow us on Twitter if you care to. And we're supported by the Office on Violence Against Women at the Department of Justice. And we're also supported by the Bureau of Justice Assistance in our Innovative Prosecution Solutions grant, which works with about 60 different prosecutors' offices around the country on violent crime strategies. We give fair use attribution to some of the materials. We've learned a lot from others, and we bring our own experience to the table as well. Jane, you want to introduce yourself?
Yes, thanks, John. Thanks for all of you for being on today. This is a topic that I think comes up more than we even realize in cases across the board. I'm a former prosecutor, having started my career at the Miami-Dade State Attorney's Office. So we were a very large office of 250 plus prosecutors. And for the first year of my career, all I did was work in a dedicated misdemeanor domestic violence unit where I prosecuted cases involving assault, battery, stalking, and violations of protection orders. And this is really where I started seeing just the pervasiveness of witness intimidation in also all of its different forms, which I really hope we get into today. I've been with Equitas for about 7.5 years, and I focus a lot of my work on human trafficking, which is another one of those crimes where we should just assume intimidation and retaliation is happening. And so thinking about ahead of time, the strategies, not only to identify it, but then how can we use it to our almost, I don't want to say benefit, but how to sort of turn it around on the perpetrator and implement some prosecution strategies to be able to still hold these offenders accountable. So looking forward to this day dedicated to one of, I think, I don't want to say my favorite topics, but I think there's a lot of great strategies out there, and looking at the co-presenters today, I know you guys will all have some great takeaways.
Thanks, Jane. And so I'm John Wilkinson, as I mentioned. I'm a former assistant Commonwealth's attorney, which is what you call prosecutors in Virginia, from the Fredericksburg area. Jane and I present together a lot, and we sort of always like to sort of compare and contrast. She came from a big office, Miami. I forget how, like close to 300 prosecutors.
Yeah, about that.
Office. And I came from little Fredericksburg where there were 4 prosecutors in the office. So my experience may be a little different, but not really that different. And when it comes to intimidation and some of the strategies we're going to talk about, it doesn't matter. Anybody can do these things, right? Sometimes we think large offices have tons of resources and are going to be able to tackle these problems much more effectively, more programming, things like that. I think there's advantages to a small office too. I just kind of knew everybody in our community, so you could just easily pick up a phone and call somebody and just say, hey, what's going on? So in Fredericksburg, when I was an assistant Commonwealth attorney, because we were a small office, you tried everything, right? It's everything from traffic offenses to first-degree murder. But I focused a lot on domestic violence homicide, sexual violence, and I was on our sexual assault response team. I also tried a lot of drug crime and gun crime as well, just given the nature of the crime issues in our community. And so those are crimes that we see a lot of intimidation associated with, as Jane was pointing out. And we didn't back then have a human trafficking unit or anything, and Jane started their first one in Miami. But I know we were running into those folks and we just weren't seeing it at the time, and probably were prosecuting victims of human trafficking back then and not recognizing what might be going on, particularly related to witness intimidation. So you'll have a couple of good perspectives from very different office settings, but I think similar responses to going after these crimes. So some of the things that we're going to talk about today is collaborating with allied professionals to maintain victim safety and achieve justice. And not just for witness intimidation, but frankly, for all crimes, it just collaboration is key. If you're going to go at these things effectively, the closer police and prosecutors work, the closer we involve, or the more we involve advocates in this work and other allied professionals, the better outcomes we're going to have. It just working together just makes everything a lot better. A lot of my experience comes from working in our sexual assault response team, or SART, where it was myself, our lead detective on rape cases, our rape crisis folks, and our sexual assault nurse examiners from the local hospital. Just met once a month and talked over these cases, and it just so dramatically improved my understanding of how these crimes work, what my other allied professionals were doing, what they could do, what they couldn't do, and they learned from me as well. And my education level about these crimes really went through the roof. And so I can't encourage people enough to collaborate and work closely with others. And Jane, I know when you were doing not just the human trafficking work, but you had to work with others to be effective in human trafficking, right?
I mean, that's where the spike in how we were able to address the cases, there was such a learning curve. And it wasn't until we started talking to folks that had been working with the population for, decades and decades, and we just weren't seeing it. We were really behind the curve. And it was the collaborative nature of the work that all of a sudden allowed us really to be successful, because we learned from them, we had strategies, and then they also helped us build relationships with folks that maybe were less inclined to feel like they had a place in the criminal justice system to disclose and to participate. So very key. And I think when we talk about witness intimidation, generally, we have to do it through that lens of, do the folks that are being intimidated feel like law enforcement and prosecutors are their best, way to deal with this? Or are we also partnering with those community advocates and people that have trust within communities and sort of build upon pre-existing relationships and demonstrate really that the criminal justice system can provide this more holistic response to victims and witnesses and communities that experience intimidation and retaliation?
Yeah, it's such a great point about working closely with others who then can vouch for you in the rest of the community or amongst their stakeholders, which we don't always have easy access to, things like that. And so I just think that's a great point and another key for collaboration. The other thing we'll talk about today is how we're going to identify the crime of witness intimidation, preserve the evidence of intimidation, and then admit that evidence at trial, or how we're going to use that evidence to advance our case. That's our final thing too. How are we going to do this to enhance our prosecution? So evidence of witness intimidation can be used in lots of different ways to improve our case, move the ball forward in our prosecution, and hopefully hold some of these offenders accountable. So those are just some of the things we'll talk about today. So when we say a witness intimidation, what are we talking about? If folks want to chat anything that they think of when I say witness intimidation, what image comes to your mind, or what are you thinking about when we say witness intimidation? What is included in that? It could be, so threats we see in the chat, which is what I typically think of: stalking, bullying, blame, threatening, pressure to not participate. So these are going to fly by pretty quickly because it's a big group. Coercion, causing fear, harassment, immigration threats, using family members, gaslighting, warning,
Actually paying someone off. I saw that. Yeah.
phone calls,
Dissemination of shameful material. These folks are on top of it, and our
Body
colleagues at Spark
Body-
would be so happy for them to mention stalking.
third parties, mobbing, taking away support for kids. This is like this is like way over the top. And normally we don't have 600 participants, so this is fantastic. Taking away service animals. So you got community shaming. You guys are hitting everything. So when we talk about witness intimidation, what I typically think, or the image that normally comes right to mind, is some sort of threat or violence or threat of violence, things like that. But it is much broader, and it includes lots of things. And then cyberbullying and financial control, all those power and control dynamics that we see in domestic violence, all of those things that are used, social media shaming. You guys have hit all these things. So it's a very big umbrella. It is not just the threats and violence that we might normally think of. It could be anything. It could be the "I love you, please don't come to court. If you don't come to court, they can't convict me." So, you know, it can be a lot of different things. And so we want to keep a very broad view as to what might include intimidation. And this is a definition that Equitas, on one of our projects, we came up with, just to be as expansive as possible when we're talking about witness intimidation. So it's anything done with the intention or purpose of preventing or altering a witness's testimony or report to law enforcement, or to retaliate against a witness for such testimony or report. So it can be anything. It can be all of those things that you all were listing off there, and it could be things that we normally wouldn't think are awful things, but are just things that people do. The sort of "I love you" stuff that might happen in some of these cases. So keep a very broad view to what is witness intimidation, so that we don't miss anything, and that we're sharing any information that we have related to intimidation with our allied partners.
And I think it's important just to note here, we're talking about sort of the behavioral definition and not necessarily what your individual statutes might look like. So I think we're going to share the federal statute, but every state, every territory is going to have their own definition. And some of them are really written with this behavioral definition in mind, and they're broad and expansive. And other ones you're going to see are very narrowly tailored and may only address something that is a direct threat of harm or bodily harm. So you want to look at what your statute is, but then you also want to figure out what other statutes might address this type of behavior. You guys mentioned stalking, extortion, as far as, if you don't do this, I'm going to release these photos, or that might be under some sort of statute dealing with the non-consensual distribution of intimate images. So you got to figure out what your tool bag is, and not just rely fully on your intimidation statute or your tampering statute, because oftentimes we find that they are very narrowly written, but you still have other tools in your tool belt.
Yeah, that's a great point. And criminal charges aren't the only way we're going to use this evidence. So it's still going to be important, even if we can't charge a particular, an I love you may not be supported in your statute for intimidation or something else. But it might be an important piece of evidence for me at my trial to explain maybe why my victim didn't appear. Well, we know that she got these messages or these jail phone calls or what have you from the defendant saying, I love you, please don't come to court, things like that. May not constitute a crime under our statute, but it's going to be evidence that I can use. So I definitely want to know about that. So we just threw up one of the federal statutes on witness intimidation as an example. Every jurisdiction should have some form of this. And as Jane pointed out, it's really the key is going to be, what does your jurisdiction statute encompass? What behavior does it encompass? And is it prohibited by the statute? Or do we need to look at other statutes? Or is it not going to be a criminal charge, but we can still use that evidence in other ways to advance our case? And so the fairly typical thing would be someone who kills or attempts to kill someone to prevent their attendance or their testimony, prevent them from producing evidence, prevent communication to law enforcement. And so anything like that, we want to think about, will it come in under our statute? If anybody wants to know what their statute encompasses, just let us know. We're happy to do the research for you and send it to you. So just that's one of the things we do. There's no cost to we're funded by the Department of Justice to do these things, so there's no cost to you. So you can just reach out to us. Our contact is at the end of the presentation. So the first part of the statute covers killing someone or attempting to kill someone. The next one would be using physical force or threat of physical force against someone to influence them, delay them, or prevent their testimony, withhold testimony or records, or alter, destroy, or mutilate evidence, things like that. All the things that you can think. Evade legal process, so trying to get someone not to be available to come to court, be absent from an official proceeding, or hinder or delay or prevent that communication with law enforcement. And then last, whoever knowingly uses intimidation, threatens, or corruptly persuades. So they have this interesting language in the federal statute that just talks about persuading someone to do something wrong, corruptly persuades. There has to be an intention to get them to do something wrong, to delay or prevent that testimony, withhold the record, or alter or destroy evidence. And so this statute, I think, is a little more broad than maybe a lot of other state statutes, although it just depends on your state. Some of them have more broad, inclusive behavior covered, and some do not. Evade the legal process, be absent from the proceeding, hinder, delay. So those are the typical things. And then there's retaliation is the other one. So, and we don't want to forget about that, right? Obviously, we're concerned as prosecutors up front. We want our witness to come to court. We want them to testify. We want them to be safe during that period. And a lot of times, though, and I think Steve Siegel, who's going to talk after us, might go into this. As a prosecutor, once that case is over, I forget about the witness and what might be happening. And I don't want to do that because there could be retaliation that's going on. And it's basically the retaliation statute covers all the things that the intimidation statute on the front side covers. So whether you're going to kill someone to keep them from attending, providing information to law enforcement, use physical force, threats, things like that to prevent them from attending, or sharing information to law enforcement. So all of those things are covered. Some of the strategies that we want to think about as we're combating witness intimidation is we think about how folks are intimidated and where they're intimidated, and what can we do to make folks safer. And then when this does happen, how can we gather that information so that we can use it in our case? And so one of the first things we want to do is educate victims about witness intimidation and about the value of the evidence that may fall in their lap, right? They're the target, they're the ones being intimidated. So they're likely to be in possession of that evidence of intimidation. And they may not understand that it's important. In a domestic violence relationship, for example, that kind of power and control or intimidation that the abuser tries to exercise over their victim may be their life day in, day out, and it may not seem unusual to them, but it could be important evidence for us if we're trying to prosecute that abuser for an act of domestic violence. We also want to identify those places or opportunities where abusers or defendants intimidate their victims. And so when we think about witness intimidation, it could happen in any crime, right? But it's most closely associated, or we see it regularly anyway, in gang, gun, drug crime, and domestic violence and human trafficking crimes. That's where we see witness intimidation on a regular basis. It's the bread and butter of those criminals and how they kind of evade accountability through this kind of intimidation and the wide variety, from violent things to all the way to the "I love you, please don't come to court" stuff. So if we know that, what can we do to make victims and witnesses safer, and how can we reduce those opportunities for those individuals to intimidate? And so we'll talk a little bit about that and figure out some strategies there. We also want to preserve the evidence of intimidation, and we want to think about how we can preserve that evidence, how we're going to collect it, and how we're going to preserve it. Even though victims may be the ones who fall into possession, or the evidence falls in their lap, they are in receipt of it because they're the target. I don't want my victim to be an investigator. I want them to stay safe. I don't want them to look for that evidence. If they come into possession of it, turn it over to us, and we'll also proactively look for that evidence. And so we'll talk a little bit about that. And then we want to charge intimidation crimes where we can, because I think a lot of times we don't think about that charge in our domestic violence cases. Well, of course, he's going to be talking to you, and of course, he's going to try and persuade you. It might constitute a crime. He might be threatening. It might be a veiled threat. It might be a coded threat, a code that the victim knows quite well. And we don't understand the impact of whatever it is that the defendant might be saying or doing to that victim. And so the more we know about it, the better we can address it. And if it does constitute a crime, we want to charge that crime. We'll talk a little bit about that. And then the last one is we want to use the evidence of intimidation effectively in our cases so that we know that we are using that evidence additionally to explain things. It might demonstrate a consciousness of guilt. It might show that this is a particularly terrible defendant. It might explain the absence of a victim, and it might support other motions that we'll talk about as we go through. And we will be sharing the PowerPoint. I think Richard said that they'll send out the recording of the presentation and the PowerPoint. And I see somebody wants to know the Georgia statutes, so we'll make sure. I don't know if we can capture that email.
I just copied it, so we'll try to get back to you. But probably the best thing to do so that we remember all this is to send us an email, and we can get back to all you guys. Most of those we probably already have pulled, so it's just a matter of getting it to you.
Thanks. Maybe I shouldn't have said that in the upfront.
I know. I'm like, oh no, John.
And this is Rachel. We'll make sure everyone gets, if there's questions that don't get answered during this timeline, we'll pull those together and share with the presenters, and then send that follow-up to the attendees as well, to make sure no one feels stressed that you all don't have to capture it and that their questions don't get answered.
Awesome.
Thanks, Rachel. This quote is from a study. I think we're going to refer to it a couple of times as we work through the material. Meet me at the hill where we used to park. And it's really looking at how intimidation occurs in domestic violence cases, intimate partner violence cases. And they, during the course of this study, what they did is they listened to a lot of jail phone calls. And I'm sure those of you who do this work, you understand, probably have listened to those calls as well, and what sort of almost a gold mine they can be of evidence. But they also, you can get a sense of what are these strategies employed by perpetrators. And here they, identified what we've really talked about already, which is that there are these sophisticated, it's not just "I love you" right off the bat. It's a sophisticated sort of process of emotionally appealing to the victim, to the family, and also with this intention, not only say don't come, but also to sort of minimize their actions and gain the sympathy of the victim by portraying themselves as the victim. And it's this process that it occurs in. And I think we'll go through a little bit of that in a second.
And so all the techniques that they're at their disposal, they're going to use, right? Power and control is for those not familiar with it, are the dynamics that cover folks in domestic violence relationships, abusive relationships. There's all sorts of elements to power and control that these abusers use to exert control over their significant other and make sure that they don't reach out to law enforcement, things like that. Witness intimidation is also going to be powerful tool, and it's on the power and control wheel. So it's one of the elements that is regularly used. And then force, fraud, and coercion are part of all of these things. We think about that closely associated with human trafficking, but it happens in all these crimes. And that's how these guys get away with this stuff.
And I think what can be helpful is when we're trying to say, okay, let's try to be proactive. Let's try to identify witness intimidation and almost be ready for it. One of the things that you can do is you can look at, in these cases of domestic violence, where we really have this power and control being the center of offender tactics. And in human trafficking, force, fraud, and coercion is the means that they're perpetrating their crime. If we can identify how they're perpetrating their crime, we can also kind of preview what tactic they're going to use for witness intimidation. So as somebody mentioned in the chat, threats about immigration. Well, that didn't just come up when it came to witness intimidation. That more than likely was a form of abuse that was used during the course of their intimate partner relationship or in the course of a human trafficking enterprise. So if that's part and parcel of the underlying criminal activity, we will know that the offender will continue to use that tactic. So if financial control, which we know is present in upwards of 85% of intimate partner violence cases, well, we can expect that the witness intimidation is going to look a lot like that, with threats of, how are you going to pay the rent? How are you going to take care of our children if I'm not able to do that for you? So we can kind of prepare ourselves if we collaborate and work with our victims and our victim advocates and partners to sort of dive a little bit deeper into what the underlying crime and relationship look like. And then we can preview that for witness intimidation.
Yeah, so those are great points too. And it prompted a question. What if you were not in a relationship with a person, but they are trying to force you to be in a relationship with them? And so I think at least my initial response would be, this is probably somebody who uses these tactics regularly in their relationships, and they're maybe using them to force you to be in that relationship. And it might also be something that is going to evolve maybe from a domestic relationship into a human trafficking relationship, depending on what's going on. Jenny, did you have any thoughts on that one?
I was just going to say that would be a situation where I'd really want to look into that, offender suspect's background, because oftentimes this behavior is something that maybe escalates or they've done before. So that's a partnership with investigators and looking at, not maybe just criminal history, but civil protection order history. You may be able to dive a little bit deeper and figure out, okay, what is the pattern of behavior for this particular offender? And that would probably give you a lot of information.
Yeah. And then there's another comment about this happening in elder abuse cases, and that we maybe don't focus on it as much. And I think that's a great point, because sometimes these crimes and these behaviors are just much more subtle. And when you're working with a vulnerable population, say as an elder population, a vulnerable adult, the methods of being able to control that person or being able to threaten or intimidate them become broader and maybe less clear to us, because they know the things that they can do to instill fear in that person. I'll leave you, you'll be alone. Who's going to take care of you? Who's going to help you use the bathroom? Who's going to manage your finances? And so we should have an eye toward those things.
Yeah, I really appreciate that being brought up. And just to expand about it, when victims and offenders know one another, when there's any type of pre-existing relationship, there's just much more likely that that offender knows enough to press the right buttons or make the threat that they know that person has the biggest fear of. So in elder abuse, oftentimes we'll see it where it'll be, well, you can't stay in your own home and you'll have to go to some place, you can't stay there. So anytime somebody knows you on that level, you're going to have these techniques being used, these emotional pleas being used. And so that's sometimes, on the other side of the guns and the drugs and the gang crime, where in those cases, they know probably the community and they know the neighborhood and they know a lot of people. And so it looks a little bit different, but really it's anytime somebody has that sort of knowledge of the victim and their vulnerabilities and their fears, then the offender is going to, of course, sort of take advantage of that.
And the other thing is, I think this evidence, and I think Jane alluded to this, is that, say in a domestic violence case, having some of the evidence of the things that this individual does to control them, whether it's the financial control or just different things, the classic one that I always think of is the abuser who regularly checks the odometer on the car so that they know the victim just goes to work and home and goes nowhere else. That is not a crime itself, but that's powerful evidence that would help me explain to a judge or a jury that this is not just an argument that went bad, but this is about power and control. This is an abusive relationship. And so identifying this type of information is really important because we can definitely use that. Doesn't necessarily mean it's automatically going to come into trial, but if I don't know about it, it's definitely not coming in. And I can create an argument or make an argument to explain to the court why this is relevant and why it's important to demonstrate that this isn't just a fight, this is something else. I think people recognize from those types of evidence that financial control, isolation, other things, checking on the odometer, that control, that this is not a typical relationship, something else is going on, and that's going to help us get that conviction for the real behavior that's going on. And then someone mentioning it happens in child abuse cases as well, may intimidate family members to get the child to recant, or they disappear, things like that. And that's also very true. It happens in all these crimes. So our first strategy we want to talk about is how are we going to educate the victims about intimidation? We want to talk to them about witness intimidation just to make sure that they're aware of it and that it could be important evidence. And so we want to know what's going on as the case is progressing. And, we anticipate that once an arrest is made, that's when the perpetrators may start their intimidation process, or as we get closer to trial. So different folks in the system might be meeting with the victim at different points. As prosecutors, we're meeting with them closer to the end as we're getting ready to try the case. And so I just want to have conversations with them, as should everyone else who's working with victims, about witness intimidation. What is has the perpetrator contacted you? Has anybody contacted you about this case? What are they saying to you? Are they making it difficult for you? Do you feel like it would be difficult for you to come to court or testify? So we want to keep an eye on that because that can be helpful to us. We also want to advise the victim on what to expect. A lot of times, folks, particularly if you're a victim or a witness to some sort of gang violence in a particular neighborhood, folks might feel very afraid to come forward because they know the stop snitching mentality, and there could be potential retaliation based on that cooperation or participation in the case. So it's difficult for them to come forward, but there may not be a real credible threat going on right at that time. And so we want to keep them grounded, figure out, what's really going on. If there's something going on, we want to respond immediately, treat it seriously, and we want to keep them safe as we can with advice and help on how to maintain their safety, both as they go and come from work, school, wherever they're going, and online, as more and more people live their lives virtually. We want to make sure that we are keeping them safe everywhere they go.
And I think we need to also tell them what to expect, because while we're talking about, and you guys are coming up with all these great examples of how intimidation actually occurs, a victim may be thinking, oh, well, intimidation is when, I wake up to a horse head next to me in bed, and chat the movie reference, if you guys got that one, might be dating myself a little bit, but they may not know that we want to know about the other types of intimidation or the other emotional pleas or tactics that the defendant or the defendant's family or friends are using. Nice job, guys.
Oops.
It was The Godfather. I don't know who got that first, but I'm glad I wasn't the only one.
That's
And we
great.
also, much like in our cases of stalking, unfortunately, the victims are often the ones that have the evidence that we need to preserve, right? So we need to let them know simple ways to preserve evidence, including just, screenshots on their phones, or now you can actually, do screen recordings on your phone and to capture, a string of emails, or there's other apps that allow you to sort of do multiple screenshots and stitch them together. So you're demonstrating that you're not, leaving out key pieces of a conversation. So lots of easy ways that victims and witnesses can preserve this evidence. And unfortunately, sometimes it's really going to be, we're going to rely on them to do that, whether it be, recording a voicemail or taking those screenshots or whatever it is. So having that conversation, and then also letting them know who their point of contact can be when they're not in immediate danger, right? So calling 911 obviously is always what we need to be recommending when somebody feels unsafe and in danger. But if it's a series of missed calls that they show on their phone, and they don't really feel like, especially if this is part and parcel of a relationship they've sort of lived with for a while, they may not think to preserve that, or they may not think to, they don't want to call 911, but they still want to let us know, and we need to let them know we want to know. So a point of contact where they can just say, hey, I got a bunch of text messages last night. Can I come by and show you this, or can I send you this screenshot? But we also don't want to be minimizing any contact that they are receiving by the offender. So that's a sort of the balancing test there of making sure they know that any contact can be potentially dangerous. And oftentimes, especially if they know the victim, they're sometimes the best barometer of their own safety.
Yeah, I agree 100%. And that last one's tricky because I feel like sometimes we do things in our own jurisdictions that are just sort of standard practice, like, oh, I'll call the defense attorney and tell him to tell his client to stop and stuff. But you really want to respond, and we'll talk about things that we can do to respond to these things. If somebody's trying to get at your witness or your victim, we need to respond forcefully. And I think we should take all of these seriously and think about bringing it back to the court's attention, things like that, particularly if there's been an order of no contact, et cetera. So we definitely want to not put victims at risk. Safety is the first thing and foremost. And I just always think, and of course, from my own practice, I think just sometimes we would put the safety of our case ahead of the safety of our victims sometimes. And we never want to do that. Safety might mean, the victim safety might mean maybe we have to make tough decisions about if we're going to be able to go forward or not, because it's such a dangerous situation. Going forward is almost always going to be the best course, but you might have a case that's unusual and it might be safer not to go forward. We want to connect our victims with the services to help educate and engage them in that safety planning. I think our advocate support folks do a great job in the safety planning area. I want to check in with victims. As the prosecutor, I might be interviewing a victim prior to trial, which is coming up, and maybe they haven't revisited their safety plan in a while, and maybe circumstances have changed. So I definitely want to check in and see, has anything changed? Do you still feel okay? Do you have a plan if things go bad? Do you have ways to keep yourself safe, either in place, or do we need to move you somewhere if we have those resources available? And we need to figure out if they have that ability or willingness to relocate. And Steve's going to talk a little bit more about that. But some folks don't want to relocate, and what can we do to keep them safe in place? And those that do want to relocate, how can we accomplish that? Do we have a program, or do we have resources in spite of not having a program that we can still leverage to help folks? The last one of this, and Steve's going to talk about this, and this is taken straight from my working with Steve Siegel for years now, is to support that lifestyle change that the victim may want to make to be safer. So it's one thing if you have a witness relocation program or a witness protection program that you're going to help somebody and move them. It's easy to just say, okay, we're going to move you over here, and now you're good and safe and on your own. But it's tough for someone to just pick up and go to another place, and us to expect them to just do fine there. So we might need to support them with the lifestyle change. They're not going to be able to re-engage with their community that they've known maybe their whole lives, or the folks that they've normally hung out with, because that might put them in danger. And so we have to think about, is this reasonable? Is this something somebody can accomplish without help? So this is a witness intimidation brochure that we're happy to share with anybody. We have a template, so you can create one for your own jurisdiction and include the information you want to include. But it's just something to help people understand what might be happening to them now that they are a victim or a witness in a crime, and the crimes that we see it closely associated with, and what you should do. Call 911 if you're in any kind of danger. Call your detective. Call victim witness services, call the state's attorney, whatever it might be. And then the important tip here in the blue shaded box, be sure to save any emails, text messages, voicemails, or other evidence of intimidation, because that could be helpful to us. This was done at the Baltimore State's Attorney's Office, and they produced it in both English and Spanish, and hard copies, and there's an online version. And it lists a lot of their services that they have, so that people are aware if you need court accompaniment, or if you need a ride to court, if you need someone to escort you from the parking garage or what have you to the courtroom, or are you going to meet at the prosecutor's office, which may be in the courthouse or maybe in a separate location, and then we'll escort you over. So it has a whole bunch of different things in there, and is helpful for folks who might be going through this.
And this is one that was created by the Denver City Attorney's Office, so with the same purpose, to let folks know what to expect and what resources are out there. I like this one because it's geared towards intimate partner violence cases, and it actually has quotes as if this is the offender speaking. And so we've definitely heard that victims who have read this, they may not, when they first get the brochure, like kind of put it away, and then they start receiving those jail phone calls, or they start hearing from the offender, and the offender is literally saying exactly what is on this brochure, or very near one. And so this one I really like. When I worked in Miami, when I found this resource, I just left the office and I sent it to my colleagues in Miami, and they actually sort of redid this, but for language appropriate to trafficking cases. And so I think, the Denver City Attorney's Office is very generous with this. And so this might be something of interest to you as well. We have the link here in the materials for you.
Oh, and this is the second page, and the Denver one is available online as well. And Denver, you would have to sort of copy it on your own. The intimidation brochure, we have a template, so you can just fill in your own information on it. So we'll share that with Richard and Rachel, and they can share it with others. And then, So we had talked about, you want to do this, Jane?
Yeah, sorry. This is from that quote, and we talked about the jail phone calls, meet me at the hill where we used to park. I always get that inverted. So they actually saw this sort of 5-step process that was really replicated in these calls and in these relationships. And what they found is that the beginning, the first contact, perhaps the victim is still very resolved and strong and maybe kind of pushing back on what the defendant is saying. And this could be, if you're an investigator out there, this may be familiar to you. Some people call this the golden hour, where a victim has, maybe something acute has happened in the home, some violent situation. And the victim at that point is feeling strong and resolved and is willing to disclose more than they would be sort of later on in the case where this is happening, right? So the next step is that the offender starts minimizing the abuse and starts casting themselves as a victim. This happens in many different ways. It may be, blaming alcohol, or blaming the victim. It may be casting themselves as a victim for having to still be in jail. But then eventually what happens is that this sort of pivoting happens, and now it becomes they don't understand us. Nobody knows us. Only we know us and our family. So then we start seeing the victim sort of aligning themselves with the offender, and it then becomes live for me. It's us against the world. And then there's the developing of the plan. And that can be anything from, don't show up to, go down to the court and file a null pros affidavit, or, whatever you would call it, to quote, drop charges, or, say you started it, or maybe, make it so that it's a self-defense claim, whatever that plan is. But it sort of goes along this pattern. And again, I think that this is something that victims might really align themselves, much like that Denver, where they have the actual quotes. This is also something that I think working with victims, and especially those that, we're now engaging with as survivor advocates and as survivors who have now gained a lot of professional experience doing this work, they would share, I would see this and I would see myself in this. And perhaps that's a way for us to, work with or have our victim service professional allies work with victims so that they can be prepared. And so that when they start seeing this, they go, I know what this is. This is actually another tactic that's being used.
Yeah, this is great. There's a couple of quick questions I just wanted to touch on, particularly this first one about coercive control, which I know my answer would riff off of things I've heard Jane say about human trafficking. And particularly, so this is something that we have to pay attention to in the legal system and as prosecutors, because the first thing we're going to have to do, say in a human trafficking case, is to explain to that jury or get them thinking that this doesn't mean these people are handcuffed or behind bars. These guys are able to control them without doing that. And so you've got to get them on that page very quickly. And the second question about someone who's reached out, who was a convicted felon who murdered your nephew, that to me is absolutely someone who's trying to somehow garner control over you by reaching out via Facebook and asking you to be a friend. That is something that person should be blocked and shouldn't be allowed to do that. But Jane, did you want to weigh in on either of those?
No, I just wanted to share that we actually have been addressing the sort of change in language, yet it is, I think, part and parcel of the original power and control wheel that was developed by the Duluth Project. Subsequent to that original wheel, a lot of people have been adapting it and adding to it. And there's like one that's really focused on digital and electronic control, others that are for particular populations. And there's another one that's called the maze of coercive control that goes to what you're talking about. And we recently at Equitas recorded a quick 1-hour training on capturing coercive control in our charging strategy. So I welcome you to look for that on our website. I think it literally went live last night. So we are kind of making sure we're thinking of that as well. And just expanding on some of the OG work that was done back then.
All right, so how are we going to reduce opportunities for intimidation? So how are we going to get ahead of this and be more proactive? And so one of the things we want to do is, again, be engaged with our victims and listen to what their safety concerns are. And remember that if you're working collaboratively, you probably have a good in with victims through your advocacy, your community-based advocacy folks in particular, whether system-based also, but the community-based folks really get the information from the victims sort of raw, because they know these folks are just here to support them. Everything they say is confidential. So they couldn't share with us that victim A told me X, but they could share with us, hey, a lot of our victims don't like coming to court because everybody's thrown into the same waiting area and they feel threatened while they're waiting there. Okay, so is there something we can do with that about that? Or that they don't, the police make them do X when they're interviewing them and it makes them uncomfortable, whatever it might be. So we want to find out what they're experiencing and see if we can't improve our response. We also want to engage with our allied partners, allied professionals, to assist with whatever we can. Transportation, accompanying to the courthouse, which we talked about. Most important, I think we want to focus on court personnel. Are they trained to recognize intimidation that's going on? I think anybody who's either been a prosecutor or an officer or a witness at court or an advocate supporting folks at court, court clerk or a judge recognizes or knows that intimidation is happening at the courthouse. And sometimes it's happening in the courtroom while a witness is on the stand. So how can we respond to that better? One, do we have a response protocol? Do court personnel know they should be documenting anything that they see happening, bring it to the court's attention so we can exclude that person properly from the courtroom and put it on the record so that we have a record of what happened and it'll protect the case overall. And of course, we want to use those spaces in our courthouse that can help us keep witnesses safe, witness rooms where we typically meet with, but the defense also meets with folks. Can we use some of those to keep people protected in these places?
So John, one of the questions that came through the chat was, or maybe it was a comment, was sort of talking about now that so many of these court hearings are via Zoom and online, and how that actually may provide additional opportunities for intimidation. And in fact, I think kind of early on, there was a case that I saw that made the national news, where it was a domestic violence case. I don't know, I can't remember if it was civil or criminal, but they actually had on camera, as the victim was there, they had the offender sort of come onto camera and do this intimidation on the camera. Now that was obviously very overt and everyone saw it, and that wasn't so smart, but you can imagine that these additional opportunities beyond the physical space that we're talking about here, and how we might be addressing that and thinking about that as more and more places are continuing to do, even, and may continue to do forever, some online hearings.
Yeah, and so, right, as technology expands and as court practices expand, and, assuming there is a post-COVID world, some of these things that we've adapted are going to stay, because some of them have proven to be very helpful in accommodating folks and getting them there. But we do want to think about that online safety aspect and how we can make sure that folks are able to stay safe, whether it's, I'm going to direct chat on Zoom somebody and threaten them that way and hope that it isn't captured or something like that. So those are important considerations, and just educating not just court personnel, but our judges as well. I just think most of our judges would be really concerned if crimes were being committed in their courtroom, right under their nose. And I mean, I know they kind of know that's happening, but if we do a good job of identifying it, documenting it, and bringing it to their attention immediately, I think the response will be much more effective. And we also want to pay attention to individual cases where this is happening or likely to happen, or we have intelligence that says a lot of members of this gang we think are going to come attend this trial today, and they're going to show up en masse and make it tough for our victims and witnesses. And so maybe if we can present this information to the court and say, we need some extra security measures for this particular courtroom on this particular day. One of the things that is regularly recommended is to have an ID check before someone enters the courtroom, and just saying, hey, we want to identify who's coming in, and here's why we want to do that. Here's why it's necessary in this case, Your Honor, because we have reason to believe these things are going to happen. And if the court allows that or orders it, that might deter a lot of folks from coming in because they just don't want to share their identification, or they might be wanted or something like that. So we do want to take time and attention and think about how we can make those victims and witnesses safer at the courthouse. It just sends a terrible message to victims and witnesses that if they're at a courthouse with judge, bailiffs, police, prosecutors, advocates, and they still don't feel safe, it just makes it tough. So we want to do what we can to reinforce those areas that we have very strong control over.
And the case law that actually addressed if requiring someone to provide identification before entering the courtroom, if that infringed upon the constitutional right to a public forum, the court, first off, it was upheld that was not an improper infringement on that right. But the court actually said, this type of intimidation, it thrives with anonymity. And we know that because of how much the internet is now used to do that, because the internet provides, at least in part, this shield of anonymity. So anytime we can do something that's within the constitutional sort of framework to bring things out of anonymity, that's one way to always be addressing witness intimidation. And I'll put that case law in the chat for you, Arcelia.
We want to ensure that the safety planning includes that tech safety, because folks will get at folks online. The National Network to End Domestic Violence has a great online safety program. If you go to their website, nnedv.org, they have great resources there. If there's going to be an interview with the defense, as a prosecutor, we cannot interfere with the defense access to witnesses in the case, but a victim or witness has the right to not talk to the defense if they don't want to. If they do want to, they might just want the prosecution present. They can have anybody present they want. It might be an advocate, it might be somebody else, but we can be present if they're uncomfortable talking to the defense on their own. And then where there's that history of intimidation or tampering, this is what we've been talking about. We'll ask for additional security measures, say at the courthouse, make a record before the judge so that the judge is very comfortable saying, yes, I'm going to order that based on the evidence that you have provided me. What my old boss became a judge, and he said the judge is the most powerless person in the system, because if you as the prosecutor don't bring me the evidence, there's nothing I can do. That's I never really agreed with that, but that was his take on it. And so I think Steve Siegel's going to talk a little bit about relocation and how that works, but do we have a formal relocation program? If we don't, do we have other resources? Does our housing authority, could they help us in relocating folks that are using public housing? Can we use victim compensation funds to argue that these individuals should be reimbursed for the cost of relocating because they're a victim of a crime, they've been threatened, or there's a credible threat against them, and we think they need some help. And then there's the Federal Victims of Crime Act funding as well. And then if you have a formal program, what are the parameters of it? Are you familiar with it? And can you take advantage of it? If you don't, is there a way to convince your state or your locality that we should dedicate some funds to formal relocation?
And I wanted to comment on, in the chat, somebody earlier had said, when this financial control and then these financial tactics are used, we need to be prepared to also figure out, okay, that's a real, it's a pervasive tactic because it's an effective one, right? So really making sure we have an understanding, or at least our partners have an understanding of how the compensation programs work, both on a state level, on a federal level. Also, what other partnerships can you have in your community when you may have something as simple as, I need to move, or I need to have some time to find a job, or this sort of just dearth of financial support. And so I think as a prosecutor, I sort of knew the brochure that had the Victims Compensation Fund information that was in my office, but I didn't really know all of the resources that were available, both through the system and through the community. And when I started doing the trafficking work, we were building that response at the same time. And I started learning about all of these opportunities for folks to sort of connect with different service providers within the community to fill a lot of those gaps. And so just knowing the lay of your land is really important.
Yeah, it's another advertisement for collaboration. Because one of the things I found is that our community-based advocates can do a tremendous amount of work that I don't have to do. Like they can take a lot of steps and to connect people with services and help them through navigate systems and things like that. Like I typically don't have time or familiarity with, and it's just great when you have those partners working with you. All right, so how are we going to identify witness intimidation? And then how are we going to combat it? So we've talked about, it could happen in any crime, but we know the crimes that it's typically going to happen in: domestic violence, gang, gun, drug, human trafficking cases. So let's be prepared in those cases that there's going to be intimidation, and what are we going to do about it? So we want to talk with our victims about it, educate them about what to do if things happen, and find out about the history that might have occurred, say, in a domestic violence case. What do we know has happened previously that's going to educate us about this crime, or help us prove this crime, because we can use that prior evidence in this case as well. And then monitoring jail phone calls is so important. I know it is a bit time consuming and often unpleasant to have to listen to some of the conversations, but you can find a lot of great information on these jail phone calls, even though the defendants know that they're being recorded. I have prosecuted a drug conspiracy that was all established by jail phone calls. I have prosecuted domestic violence cases where the information on jail phone calls was critical. That's where you're likely to hear the please don't come to court, or it's sort of it's really your fault stuff that, maybe it may not be a key piece of evidence at the trial, but that stuff could be very helpful during sentencing too, when you can demonstrate to a court after a conviction that, look at how this individual views the world and views their behavior here. They don't get it, and we need to make sure that they understand this will not be tolerated, and an appropriate sentence is necessary in this case, an appropriately tough sentence. So those jail phone calls, if you don't have the time and attention, there are usually local college, university students who are really interested in getting this kind of experience. I mean, maybe not this specific kind of experience, but experience in the criminal justice system. And for them, listening to these calls, helping them, hey, here's what I need you to find or listen for, helping them understand what's relevant, and having them go through it, and then having them, they'll eat that stuff up, and it could take a big chunk of time off of your plate.
Yeah, and just, quick tip to because we know the inmates will swap the PIN or their particular code to make the calls. So to try to inhibit us from being able to find their calls, you can also usually search by destination phone number. So when you have a known phone number, you can search by that. In Miami, Florida, we were able to charge identity theft for every time an inmate made a call using somebody else's PIN. That's not the case everywhere, but it's another plug to figure out what your statutory toolkit is beyond your intimidation, tampering charges, because it can become really effective when you're able to start charging some additional things. And in this case, in Florida, identity theft goes from a misdemeanor to a felony if you have a certain number of occasions. And so all of these phone calls were individually crimes of identity theft because they were using somebody else's personal identification number. And then eventually we were able to charge felonies on that as well. So always figure out, these little tricks of the trade.
No, that's great. We want to cross-train our jail personnel to identify and report communications within the jail. Our local jail had their intelligence section that would randomly listen in on different calls. And so they were able to alert us to things that were going. All the calls were recorded so they could go back and find additional calls if we wanted them to now explore other things. And again, we want to review the prior criminal and civil cases that might be involved, particularly in domestic violence, because this could be a pattern of abuse that's going on or a pattern of control. And so those prior incidents might become relevant to this incident. And the victim can share with us information, hopefully, that, yeah, I did that because I was afraid, or I did that because he was doing X, Y, or Z to me. And we want to also, again, work closely with our victim service providers, our community-based providers, our system-based providers. I always work closely with, and pay attention to lapses in contact, because that might be an indication that intimidation is going on right now, or power and control, that manipulation might be going on right now. So we really want to connect, make sure that we provide those support services. Not every victim's going to take advantage of that, but many will, and we want to make sure that they have access to that stuff.
And you can ask about what victims witnessed the offender do to other victims and witnesses. So in trafficking cases where there are multiple victims, there may be a case where, while this victim was still with the offender, they witnessed another victim try to leave. And they were an actual witness to how the offender responded to that other person leaving. And they can say, oh, this is what they did. They did X, Y, and Z. Well, that again will give us a preview of what to expect, and also how to hopefully enhance this particular victim's safety, both physically and emotionally.
Yeah, and someone just chatted, look at the visitor log at the local jail too. And that can be a rich source of evidence, as well as who's just going in person, because maybe they don't want a phone record or be on a recorded phone call.
And sorry, I was just going to address this next slide, because someone in the chat, when I started talking about screenshots and things like that, they said, well, what about, chain of custody? And I indicated that that's rarely an issue, although sometimes it can be in this type of evidence collecting and admitting the evidence. And I shared that we have on Equitas's website a webinar called #guilty that's all about not super high tech, but all about the simple ways to preserve, identify, preserve, and admit digital evidence. So that can be everything from our phone records to those screenshots or recordings of actual photographs of a computer screen or a phone screen. Things that are a little bit more advanced would be the forensic examination. Now you would have to prove chain of custody of the phone from victim to officer to forensic examiner. So there is an element of chain of custody in that piece. Victims can go on Facebook and archive their own Facebook records and receive a PDF of their own records. And then things like preservation letters, that's an investigative tool. So you can say, hey, Facebook, preserve this account. Don't let anyone delete it. I'll be back within the next 30 days with a search warrant. And then the search warrants themselves, and then orders of non-disclosure, which needs to be signed by a judge. But again, it would be like, hey, Facebook, I know your terms of service say that you'll let any of your users know if the government is looking for their records. But here's an order that says, don't follow your terms of service. Do not disclose this to the person we're looking at. We could spend a lot of time talking about digital evidence and this piece of it. And again, I'll just say a plug that there's a lot more resources available at Equitas, and we can help walk through some of these things, but just a little bit to think about.
Yeah. And remember, chain of custody arguments typically are supposed to just go to the weight of the evidence. Judges our judges sometimes would exclude evidence, though. And so it's good to remind them based on your case law what the impact of a chain of custody argument is. And for a lot of these things, if you have the victim testifying, you can establish that this is actually what you purport it to be. You can establish the authenticity of the document. If you don't have the victim, you might have to jump through some additional hoops to do that.
And then, look at, I even put it there. I didn't realize it was on the slide.
Yeah, so that is great. And it's a great refresher on these things that I think we do all the time, but we forget, like the foundation, and you suddenly get a foundational objection to it. And it's like, oh, now I have to scramble. And so this is a great refresher on all of those things.
And judges can be scared of this type of evidence. So you really do have to know it well enough to also be educating your judge at the same time. And along with the #guilty, the companion webinars, Safeguarding Victim Privacy in a Digital World. And that talks about a little bit more about when the defense is trying to gain evidence from the victim's cell phone or social media accounts, and what is our ethical duty around that. So lots to think about when it comes to digital evidence, which of course we know now almost every case has some level of digital evidence involved.
Right. So if we're going to take these things seriously, how are we going to respond when we identify intimidation? And so it might be in different ways. But one of the things, our go-to tools is revoke bail or bond. If there is a no contact order in a criminal case, we want to make sure, as part of a release conditions, and that's been violated. Even at the invitation of a victim, the order is against the defendant, and the order is the order. And so we can take those steps to hold that person accountable. The judges don't always respond well when there's evidence that a victim invited the contact. But I think if we have the opportunity to educate the judges, say in a domestic violence case, about the dynamics of domestic violence, and that this might not be just a voluntary invitation, it might be part of a pattern of power and control demonstrated by the defendant, then maybe we can get that judge to hold that person accountable. Contempt for violation of court orders, whether it's a protective order or a no contact order as part of a criminal case. One of the issues that has come up is the no contact order in a criminal case. In a protective order, victims typically will have a copy of that order, and the order is on a uniform registry, so it can be accessed by law enforcement, say at the scene or anywhere else, so that they know it's a valid order, even if it's an out-of-state order. But in criminal cases, victims don't always have a copy of release conditions. And so if there's a way to memorialize those conditions and share them with a victim so that they can have a copy of it, and so the law enforcement will know that, oh, these are the conditions, and we can hold this person accountable, or perhaps arrest this individual, depending on what your state laws allow for those things. We also may want to use this as evidence of a consciousness of guilt on part of the defendant. If you're innocent, why are you trying to make this witness go away? It doesn't make sense. So we may want to use that in our case. It also may help us to bring this in as a separate charge that we are going to join with the original case because they're interrelated, and the evidence of this crime is going to be part of the evidence of the overall case, or if we're going to bring it in as another bad act, something that the defendant did that's relevant to this crime that demonstrates a purpose that is allowable, say the motive or the identity of the defendant or a scheme or plan to evade detection, things like that. So there's all sorts of ways we can use that evidence of intimidation. We do want to respond to it forcefully when it happens. If we're going to charge it, so we pulled that federal charge of intimidation. Every jurisdiction should have charges like these: witness intimidation, tampering, obstruction of justice, some sort of extortion, suborning perjury, which suborning perjury is just asking someone to lie for you on the stand under oath. Bribery. Stalking is a really important one, particularly, again, I think in domestic violence cases where we have stalking behavior routinely in domestic abusive relationships, and we don't pay attention to it, and we should, because there's evidence of it, even if they're in a relationship and live together. It could help us get a lot of evidence in, because any evidence of stalking from the first incident of stalking to the final incident of stalking that supports that charge can come in as part of that charge, because it's a course of conduct that we have to prove. The identity theft that James mentioned, and there could be other things that folks want to charge. Harassment, there's computer-based crimes, cyber crimes that might, terroristic threats, anything.
I'd be curious what other people have charged, because one of my favorite things to do is look at different state statutes and think, oh, this could work too. This could work too. And so a good exercise for you guys. And a lot of people have been reaching out and want to know what their statutory scheme is. And so we'll do the best we can to respond to everyone that reaches out to us with sort of the toolbox of charges you should be looking at when you're thinking about the broader definition of what is witness intimidation.
And so our charging strategies: can we join the intimidation charge with the underlying charge of whatever the violent crime might be, because they're so closely related? And can we make a good argument for why those should be joined? If the judge is not willing to join the cases, then can we file a motion to say, if you're not going to join it, we still want to bring this evidence in because I think it'll demonstrate to the court or the jury that a consciousness of guilt on behalf of the defendant because he engaged in these other bad acts. And remember, the other acts don't have to be crimes. Sometimes a statute is called prior crimes and other acts evidence. It could be anything that a defendant is doing that demonstrates a consciousness of guilt. Anything that they're trying to do to get that victim not to come to court, to change their testimony, not to talk to the police. Whatever that might be, we want to demonstrate that and use that evidence in our case. And one of the things, if intimidation works, then we may not have a victim present at the time of trial. That collaboration with advocates and that work with keeping the victim safe is super important, because we want to do everything we can to make sure that victim is able to testify about what happened to them. But if we don't have that, how are we going to get that victim's voice in the courtroom? The defendant has a Sixth Amendment right to confront the witnesses against him. So if we don't have that witness present, what do we do? So we want to find out all the different statements that are available from the victim. Is the 911 call available? Can we introduce that? Did they make on-scene statements to police officers? And can we introduce that? Did they talk to friends and family about the incident? And can we find out when an incident like a traumatic incident, an assault, something like that happens, people often will just call a close friend or a family member to say, oh my God, here's what happened. Did they have to receive medical attention, medical treatment, or an EMT came to the scene to just check them out? And did they make statements about the crime to that healthcare professional? And these statements are potentially admissible either as non-hearsay, depending on the circumstances and the nature of the statement or the substance of the statement, and or there's an exception to the hearsay rule that keeps this evidence out, that we might be able to get it in. Questions for investigators to ask: did you talk to anyone else about this incident? So there's an incident, you respond to the scene, and they say, yes, I called my brother and told him about what happened. So now I want to know, who's the brother? Can we get that brother on the witness list and have them come to court? So if something happens to my victim and they're not there, the brother may be able to testify about this. Who else knows what's going on? Is there anybody else that knows about this? We kind of want to tie this question to a hearsay exception. And so often what we'll ask police to ask is, did you talk to anyone immediately before or immediately after you called 911? And so the idea there is, if they called 911 and it was in close proximity to the incident, that there might be an excited utterance hearsay exception associated with that. If they talk to someone immediately before calling 911 or immediately after, that person can come and testify under that hearsay exception of the excited utterance. Just a quick rundown. We'll go through this pretty quickly. Hearsay is a statement that the declarant did not make while they're testifying at the current trial or hearing, and it's offered to prove the truth of the matter asserted in the statement. So it's just a pretty basic definition of hearsay.
A basic definition, John. This is literally probably the most confusing piece of the evidence code.
Traditionally, that's what folks say. Yeah. But it's those out-of-court statements that you're trying to get into evidence to prove that what that person said was true. So these are some common hearsay exceptions. Of course, the list of exceptions is quite long, but the ones that we see pretty regularly associated with these crimes of violence, the excited utterance is a common one that is used in a lot of cases. And that's the hearsay exception that just says, if someone's under the grip of a traumatic event, that what they said during that event or while they're under the grip of that event is reliable and can come into evidence. The present sense impression is the exception that says, if someone's relaying an event as it's happening or right close in time to after it happened, that's reliable and that can happen. So that I always describe it as, he's at the 30s, at the 20s, at the 10, he's scored. You're relaying it as it's happening. The then existing mental, emotional, or physical condition are things that victims might complain about. My head hurts where I was struck, things like that. So that can come in, and we're establishing that there was an injury. The statement made for medical diagnosis or treatment is important because healthcare professionals are going to ask a lot of questions of victims, and they might be able to memorialize the account of what happened. Your courts will differ, your jurisdictions will differ about how much of that can come in. Typically an account of why they are there, anything that's necessary for a physician or a healthcare professional to treat that individual, and things that those individuals would normally expect are important to a diagnosis or treatment are the statements that can come in. And recorded recollection, folks that, particularly in stalking cases, if you keep notes about things that have happened, a traumatic event, and you kept a record of it somehow, then that can come in potentially as well.
When we're talking, I was going to say, when we're talking about what law enforcement officers should maybe ask those questions of neighbors and friends, or who else did you talk to? One of the other things that I think John was touching on is that it's so key that we also document not only the timeline, but things like demeanor and tone of voice, and what the circumstances were, any evidence of exigency or an ongoing emergency, because these are going to be the types of things that a court's going to look at when they make the determination. Is this an excited utterance? Was this a present sense impression? We're going to have to make our arguments given this type of documentation and evidence. And of course, cases will take some time to get to court. So we can't rely on our officers having, vivid memories of this particular incident. So cross-training and working with officers to improve documentation that addresses this can really help us down the road when we're making those arguments that this is admissible. These are admissible statements because of either this exception that exists or something else.
And so some of the case law, and we'll just go over this very basically. Crawford v. Washington is a case that sort of changed the hearsay rules a little bit. And they divided statements, out-of-court statements, into two categories: testimonial statements and non-testimonial statements. Testimonial statements are a little more formal, and their primary purpose is for use in a prosecution. So anything that, say, an investigator might be asking a witness is typically going to be testimonial, right? Tell me what happened, just the facts, and I'm going to document them and use them to prosecute somebody. And so the testimonial statements require confrontation. The defendant has the right to confront the declarant of a testimonial statement about that statement. More formal and for a prosecution. Non-testimonial statements are less formal, and they're sort of casual remarks to others. They would be when you tell your neighbor or friend or family member about the crime that happened to you. That's non-testimonial. You're not having that conversation to get that person prosecuted or to use those statements to prosecute somebody. You're just trying to get help. Also, statements during an ongoing emergency. So typically a 911 call or statements to an officer responding to the scene while an emergency is ongoing. Things like what's happening, who's doing it, where is he, does he have a gun? Those things, when we're trying to get control of a scene, are going to be considered non-testimonial because their primary purpose isn't for later prosecution, even though we will likely use them in later prosecution. Their primary purpose is to aid the police in meeting that ongoing emergency. And so we want to make sure that we document not just the statements that are made, but the circumstances under which those statements were made, so that we know, hey, this was an ongoing emergency, and these statements are now non-testimonial. If I have a hearsay exception, like an excited utterance, they can come in. The defendant doesn't have the right to confront and cross-examine the declarant of a non-testimonial statement. So we want to proactively look for those statements in our investigation. Medical statements to a medical provider are also considered non-testimonial. So that medical hearsay exception for statements made for purposes of diagnosis and treatment are going to be important because it may be the statements that we need to get in to prove that this crime occurred. And let's just run through this real quick. So just a quick way to analyze these things. Is the statement hearsay? So is it that out-of-court statement and we're offering it to prove that what the person said is true? If it is, then is there an exception to the hearsay rule to allow this to come in? And if there is the statement testimonial so that the defendant has the right to confront them, even though there might be a hearsay exception, that witness may have to be present to testify in this situation. And we've got this quick exercise that I think, Jane, you and I should just do.
Yeah. So this is the victim's neighbor, right? So that we want the neighbor to testify as follows. The neighbor is going to say, I've lived next to the victim for 3 years. 6 months before this happened, Jess, the victim, knocked on my door late at night. When I opened the door, Jess was crying, had a bloody nose. Jess told me Sam had just gone crazy. So is this hearsay? The neighbor is testifying to something that the victim said to them out of court. So yes, it's hearsay. We do want the court to accept it as the truth of the matter asserted, that Sam in fact did go crazy. So it's hearsay. Does an exception to hearsay apply? We've got evidence of a bloody nose, a knock in the middle of the night. We'd probably make the argument, John, right, that this is an excited utterance, that this is where there's still an emergency, something just happened and they're still under that excitement. So the last one is it testimonial? Really, anytime it's a statement to somebody other than law enforcement, we can almost always say that is not testimonial. So if we go through this 3-step analysis, this statement should be admissible in court, and we should be able to have the neighbor testify to what happened that night.
Right. And so based on this analysis, we want to look for these statements. We want to look for these witnesses, because if it's a case that's closely associated with intimidation, we know there's a chance we won't have the original witness, the victim of the crime, say, at court ready to testify. But this person may not be on the radar of the defendant to intimidate. And this might be someone we can get in and have them testify about these statements. So testimonial hearsay is admissible if the victim is present and testifies and answers questions under cross-examination. If the victim previously testified about this incident and the defense had a full and fair opportunity to cross-examine that victim or witness on this. So we just want to think about the turning over discovery ahead of a hearing, so that the defense has a full and fair opportunity. That's, typically say a preliminary hearing, which we'll talk about in a second. We might restrict the scope of cross to the scope of direct examination, meaning that they can't ask questions that we didn't ask on our direct examination. They can't go far afield in their questions. And then the last strategy that we would employ to get statements in is called forfeiture by wrongdoing, which it doesn't matter if it's testimonial statement. If the defendant did something to make the witness unavailable and intending that result, then those statements can come in, and we'll delve deeper into that in a little bit. So how can we preserve testimony if we know, we have a feeling, hey, we may not have this victim come time for trial? If there's prior trial testimony, for some reason there was a prior trial, but we're going to try them again, or we need to use that testimony and there was cross-examination, then we can use it. Preliminary hearing testimony that we might want to use if there was a preliminary hearing that we actually put the victim on. We might change our strategy in our typical preliminary hearing if we feel like we're not going to have this victim, they're going to drop out or intimidation is occurring. If there's a deposition, if you're a jurisdiction that has criminal depositions, then that might be a way to preserve it. Grand jury testimony would not be able to be used in this situation because there's no defense attorney present during a grand jury for cross-examination. So that would not be a way to preserve testimony. Preliminary hearing. Go ahead.
Yeah, I was going to say a lot of people have been rethinking preliminary hearings and how they put them on. Traditionally, you can put on a very little amount of evidence at a preliminary hearing. You're just trying to get over a low standard of proof. But the preliminary hearing happens really early in the case, and you may have a situation where a victim is in that golden hour where they're feeling that strong and resolved point. So the thought is, well, I wouldn't normally put on my victim at this hearing because it does open the victim up to cross-examination and a previous statement and things like that. But maybe if I'm pretty sure I might not have that victim later, maybe I do want to put the victim on the preliminary hearing in these certain types of cases or under certain circumstances. So to make sure that that preliminary hearing testimony is something that you could use later on, the defense has to have a fair and full opportunity for cross-examination. We can help facilitate that by making sure all the discovery is passed, by not trying to narrow the scope too much during their cross-examination, and to allow for sort of them to maybe delve into the testimony a little bit more than we typically would. And I've seen this in domestic violence cases and in human trafficking cases where there's such a high incidence of intimidation and victims being eventually not able to participate.
Yeah, usually when a defendant wants to waive preliminary hearing, that's a good thing, but they might be doing it strategically. So an argument I would make is, if I'm afraid I'm going to lose that victim and I want to preserve this testimony, is that, look, the defendant has a right to have a preliminary hearing, but they don't have a right not to have a preliminary hearing. And we're asking that the court, that we conduct this preliminary hearing because we're afraid we're going to lose this victim. And so, I don't know how receptive your judges will be, but I think they might respond and say, yeah, I agree, and you can do the hearing. So we're going to talk about forfeiture by wrongdoing, which we alluded to or mentioned a few minutes ago, because it's a great strategy to use, particularly in cases in cases where intimidation is present, because it's a great way. I think, Jane, you said at the very beginning, you know, when we are familiar with intimidation and how it works, and defendants using this to get their victims and witnesses to go away, forfeiture by wrongdoing is a way for us to use that effort against them, so to turn their effort against them. And so that's what we want to do in these cases. And it is not a new strategy, although it is not the best known strategy, or not everybody uses it. I think it's being used more and more. But it goes all the way back to a case in England from 1666, Lord Morley's case. And then the original case from the United States was a case out of Utah that involved, it was sort of a test case for polygamy in Utah, where someone, the Mormon defendant, wanted to test whether it was constitutional to prohibit polygamy. And the case didn't go exactly the way they thought, and so they ended up trying to remove one of their wives from the case, keep them away from court, and the court allowed the wife's testimony in because they had evidence that the defendant did keep the second wife away. So it is a rule of equity, meaning that you can't allow the defendant to engage in wrongful behavior by keeping a witness away and then insisting on their right to confront and cross-examine that witness. It's not fair to do that.
Yeah, which is important to know, because a lot of people see forfeiture by wrongdoing and they think we're talking about asset forfeiture or something like that. But actually, it's talking about forfeiting their right to confront witnesses against them, because they're the ones that, through their wrongdoing and their intentional act, kept the victim away from court. And so there's, you know, I think we already mentioned, this is the Confrontation Clause everyone's familiar with. This is the case Reynolds v. US, which is really a fascinating case, but it has that language that is the basis of forfeiture by wrongdoing, which is you do have this privilege of being confronted, but if the defendant, voluntarily keeps the witnesses away, he cannot then insist on this privilege. Sort of like I love the rule of equity. It's like, this just wouldn't be fair if we allowed this to happen, and it would definitely encourage more and more witness intimidation.
And as Jane was saying, it's just, you can't take advantage. I think of the clean hands doctrine too. You can't create error and take advantage of it. All those equitable remedies. This is the federal rule of evidence. I was looking at this because we collected some information related to how widespread forfeiture was. And I think over 30 states have codified a hearsay rule similar to this one for forfeiture. Not all of them are exactly like this, but over 30 states. And then I can't remember, 10 or 11 states had case law on it, but there are a handful of states that really, they don't have a codified section and they don't have case law on it. They haven't addressed it yet. So you might be in one of those jurisdictions, and we're happy to help you if this is a strategy you want to pursue. But basically, this is how it's laid out here, is it's a statement offered against a party that wrongfully caused or acquiesced in wrongfully causing the declarant's unavailability as a witness and did so intending that result. So it's basically got 3 parts to it, that you've done something wrong to keep a witness away, and you intended to keep them away. And if we can show those 3 things, then the statements that witness made about the incident can come into evidence. So again, it's not recognized. I mean, it is recognized as an equitable doctrine. Every court that's considered it has said, yes, this is a legit evidentiary rule. And so it should come in even if you don't have case law on it. And again, these are the 3 things. The victim is unavailable. So we know we've tried to locate our victim, and we've done what we can beyond just sending a subpoena. We've tried to track them down. We've exercised some effort to locate the witness, but we can't. The defendant did something wrong. And so we'll talk a little bit about what wrongdoing is to make that witness unavailable. And the defendant did it intending that result, intending the result to make the witness unavailable.
So this is one of the more modern cases that addressed forfeiture by wrongdoing, Giles v. California. It was a domestic case where there was a domestic related homicide, and there had been this prior domestic assault as well. And the prosecutor really said, okay, this is easy. He killed her. This is wrongdoing. We've got this. And in the case, the defendant said, well, actually, I killed her as self-defense. So the homicide wasn't really wrongdoing. And the court said, you hear some of the details of the case on the slide, but what the court basically said here was, you really need to draw that nexus. You can't just say there was wrongdoing and the victim is not available, but you have to show that the wrongdoing, at least in part, was intentionally designed to keep the victim from coming forward, to keep the victim from disclosing to the police or from coming to court. And the court, in its the concurrence that was written, basically said, hey, prosecutors, you just need to give us a little bit more, and said, here's some of the stuff we'd like to hear. So it was almost a roadmap. Even though they denied this particular case, the court gave a bit of a roadmap to prosecutors and law enforcement and others to say, hey, we would really like to know more about the history of this relationship. We'd like to know more about the dynamics of domestic violence and how this was part and parcel of the relationship between the victim and the offender here. And so the case stands for really how to do this in a domestic violence context and make that link between the wrongdoing and circumstantially even totality of the circumstances is all of these offenders' tactics are all designed to keep the victim from seeking outside help.
And they also talked about the history of domestic violence would be highly relevant, as would evidence of an ongoing criminal proceeding. So what does that mean? It means that typically we anticipate that a defendant is going to try and make a witness unavailable when there's a case ongoing. They're a witness to a case, but that's not the only time. It doesn't have to be an existing case. Potential witnesses, even if a case hasn't been charged, would also be included. But these would be relevant things for the court to consider when they're trying to figure out, did the defendant forfeit his right to cross-examine this witness by engaging in this pattern of behavior as in a domestic violence case.
And unavailability can be a couple of different things. You think about it as being, okay, they're maybe deceased or we can't find them, but it also could be a victim that is coming to court and has real or feigned memory loss. There's a case that talks about the defendant married the victim knowing that they could then claim the spousal privilege. And the defendant in that case said, hey, how can marrying the victim be considered wrongdoing by the court? And the court said, well, you knew that, well, maybe you married her also for love, but you also knew by marrying her, she wouldn't be able to testify. And therefore that was an unavailability. A victim could just come to court and refuse to testify. A defendant could have the victim deported. We've had some conversations about immigration-related abuse. And so that could be perhaps a foundation for that unavailability as well.
Yeah. And for that first one that cannot be located, I would just want to be able to demonstrate to the court that we did everything we could to find that witness. Not that you have to do absolutely everything, but we just made an effort to track them down. We didn't get a response at their home. It doesn't appear they live there anymore. We checked with their work. We checked with their family. Just be able to demonstrate that a witness we did seek them and try to obtain their presence at trial. The efforts have to be reasonable. They can't be done last minute, right before trial, right? The lengths you have to go to are a question of reasonableness. And so this does not mean that you necessarily have to use a material witness warrant and arrest a witness. That might be beyond reasonable. And there's other case law that talks about the impact on victims of doing that, and that's not necessarily required in every case. But you do have to be able to demonstrate that we did something to try and obtain this witness's presence. Don't be in the situation where you said, yeah, we sent the subpoena to the last known address, and she hasn't lived there in 6 months, and he or she, whatever. So let's make sure we engage proactively in trying to locate these witnesses. And Jane talked about wrongdoing, and this is a case from 2000 out of Iowa that talks about that wrongdoing is not just wrongful conduct or misconduct. It doesn't require threats, force, intimidation. It can be persuasion and control by the defendant. So those things that we see a lot in these cases, it doesn't necessarily mean that they did something particularly wrong. It may be established if the defendant directs a witness to exercise the Fifth Amendment privilege, which happens occasionally particularly in domestic violence cases, where a victim will assert a Fifth Amendment privilege, and so that becomes difficult to go through. But if you have forfeiture by wrongdoing at your fingertips, then it might be something that you are ready to move forward on and introduce that victim statements, because they are currently unavailable because they're exercising this privilege. And then this is also about wrongdoing, and from this case from 2015, it doesn't mean that they have to engage in violence or threats of physical violence. The link between the defendant's action and the victim's unavailability may be established when the defendant puts forward to a witness the idea to avoid testifying, either by threats, coercion, persuasion. It could be that corrupt persuasion we saw in the federal statute earlier. So this is important evidence, and we need to know about this. Anything that the defendant has done, or anything that allies of the defendant, someone is acting on behalf of the defendant, anything that they have done to make the witness unavailable. One of those things that we listed off: a witness who refuses to testify, fails to appear, asserts a privilege, or may have been murdered by the defendant. This is a case from Ohio that was kind of an interesting case, because the evidence, it's sort of a case where it was a murder case, and then it wasn't just the victim of the original murder. The defendants just started murdering every witness possible. It was kind of just like a crazy sort of case. But the defendant in the original murder case, the court let in the evidence through forfeiture by wrongdoing, statements that other witnesses had made to police about the defendant being the murderer. The defendant appealed his conviction, saying, hey, the prosecution never was able to show that I did anything to make those other witnesses unavailable. And the prosecution was able to present a ton of evidence about the efforts that went into killing off all these different witnesses and making them unavailable that way. And the court found that the prosecution met the standard of proof in that case, which was preponderance of the evidence. So in almost every jurisdiction, not every jurisdiction, but almost every jurisdiction, in a forfeiture by wrongdoing hearing, to demonstrate that the defendant gives up his right or forfeits his right to cross-examine, confront and cross-examine the witness of the declarant of the statement, the standard of proof is preponderance, not beyond a reasonable doubt, not clear and convincing, but a preponderance of the evidence. Just more likely than not that this person is unavailable because of the defendant's intentional intent to keep them away and the wrongful act that they engaged in. So that's a huge advantage. There's 3 states where it's clear and convincing: Washington State, New York, and Maryland. So in those 3 jurisdictions, the standard of proof is a little higher. It's clear and convincing evidence that they did that. The court in this case said the circumstantial evidence, there wasn't a direct link to this defendant that he engaged in any of these activities, but the circumstantial evidence was overwhelming, and they certainly met that standard of proof, preponderance of the evidence in this case. So I think we've talked about some of these things that we want to look for evidence of wrongdoing. Jail phone calls can be a rich source of evidence. History of the relationship, prior criminal and civil cases, other witnesses to the intimidation. It could be a detective where a witness told them they were afraid the defendant had been doing something. Could be some other person that the victim shared information with. Testimony at prior hearings. All of that can be evidence of wrongdoing. in our forfeiture by wrongdoing motion.
And one of the great ways that this is such a strong strategy is that forfeiture by wrongdoing is a pretrial motion. So you're going to have this hearing outside of the court, outside of the jury. And in that hearing, the typical rules of evidence are not required. So oftentimes you can have affidavits. You can have, friends of the victim come in and say, hey, this victim, the victim told me that they're afraid, or that they've been getting these phone calls, or that they are going to move. And so you can bring in hearsay to establish this, which makes it, when we talk about the lower burden of proof and then the lower standard of, admission of evidence, it really is an opportunity for us to educate the court. And even if it's unsuccessful, you're putting before the court all of this additional information, which is educating them about, what does the true nature of this case look like in the relationship here.
Yeah, in that previous case, that Henderson case, they introduced evidence that a prosecutor had about conversations with the defendant, text messages from the defendant to the prosecution, all of these things to establish what had been going on, the wrongdoing that had occurred, to make that witness unavailable. So think broadly, but think about who is going to testify, how are you going to get this evidence in? And think about, it is a pretrial motion, but in some of your cases, you may not know that victim is going to assert a Fifth Amendment privilege or refuse to testify until you call them as a witness. So if you can do it pretrial, say because you know the witness, you cannot locate the witness, you anticipate they won't be present, or the witness has been murdered, you can do it pretrial. The court may not rule pretrial if it's unless it's a deceased witness, but may not rule pretrial and may want to see if the witness shows up before they rule on forfeiture. But if it happens during your trial, then you're just gonna maybe have to argue it during trial, make an oral motion. But you want to have the evidence of forfeiture ready for each witness. So you might want to keep your trial notebook, your case file coordinated so that you have at your fingertips the evidence of forfeiture if this witness asserts a privilege, fails to appear, something like that, and ready to go and make an oral motion on the spot. Circumstantial evidence is completely fine in these cases. It doesn't have to be direct evidence all the time. It extends to potential witnesses. So there doesn't have to be an ongoing trial. Most of our cases, we're going to find it in ongoing trials, but a lot of the case law relates to drug conspiracies where there's a confidential informant working, and then the drug gang finds out that there's a confidential informant, and then they kill that witness before any charges have been brought. And so you can use forfeiture even in a situation where there's a potential witness, even when there's not a current case. And I think Jane talked about this earlier. It doesn't have to be the sole motivation to eliminate the witness or remove the witness. It can be one motivation, as in that one case where there was marriage. So maybe you were in love with them and you married them because of that, but you also did it to make that witness unavailable. So you only have to show that they were motivated in part by that desire to make the witness unavailable. It does, we've talked about this, it requires the hearing outside of the jury. So you do have to have that motion either pre-trial or during trial, where you're going to ask the court to consider introducing that witness's statements under forfeiture by wrongdoing, because we have this evidence that this witness is asserting a privilege or refusing to testify based on wrongdoing by the defendant. Maryland, Washington, and New York require clear and convincing testimony evidence. The hearsay evidence, or at least the rule is Rule 104 in most jurisdictions, and it's that the rule says that the rules of evidence, the court's not bound by the rules of evidence. I know some judges may still want to impose some rules, so I'm not sure you could just proffer the evidence of forfeiture. You may need to call a witness and establish it on the record. The statements that you're seeking to introduce, so in your forfeiture motion, you're going to say, here are the statements that our witness is unavailable. Here are the statements that the witness made that we want to introduce. And here's what the defendant did to make the witness unavailable. And here's the authority for why that should come in. We do have sample motions if anybody wants one that we can share with you. You might want to use an expert witness to educate the court on maybe the dynamics of domestic violence, witness intimidation, maybe gang dynamics, things like that, to understand, so the court understands these things have meaning, these things that these witnesses did, these defendants did, have a meaning to those individuals. And they may reserve ruling on this until we know whether or not the victim's going to come. One last area that this is really from New York and is pertinent to New York because New York does not have a codified rules of evidence. And the question is a witness who is present, testifies, but recants, are they considered unavailable? So usually the witness either has to be absent from the proceedings for whatever reason, or is present but refuses to testify or asserts a privilege, right? But in a lot of domestic violence cases, a victim will take the stand and recant what they said. So can we use forfeiture by wrongdoing in those cases where the witness isn't technically unavailable? And in New York, where the court creates all the rules of evidence, they basically said, yeah, you can do that. That witness is unavailable in this circumstance because the defendant has just changed his strategy slightly. Okay, it's not going to work to make you not come to court. So now I need you to come to court and say something that's untrue. And so the prosecution should be allowed to introduce those original statements, even though the victim is present and testifying. Their testimony, their original testimony is unavailable, and as a result of the misconduct of the defendant. So it should come in. And the other case related to forfeiture basically just said, look, you're just painting a target on these victims to make the defendant tell them, change your testimony, do this, do that. You're not protecting them. And so we can't allow this to go forward. We have to allow the original statements to come in under forfeiture in these cases. May not work in every jurisdiction. Go ahead.
Yeah, I was just going to say, it just goes back to that, 5-step plan. And the last part is, what's our plan? And if this is just an opening, of course, then the defense is going to say, the defendant would say, okay, well, our plan isn't for you not to come. Our plan is for you to come and recant. And even if this is unique to New York and for lots of reasons, I think we like to put it out there as, like an emerging issue, but also, let you guys know that if the victim is taking the stand and recanting and you don't have forfeiture by wrongdoing, there are other strategies to sort of let the jury know what's really happening, how you can bring up all this additional information during maybe a soft cross. So this is one of those things where I'd say, reach out to Equitas. If you have a prosecutor, you're working with a prosecutor who's got one of these tough cases. That's where we really love the work we do one-on-one, because it's so fact specific. But there's lots of strategies, even if this maybe isn't available to you.
Correct. So going forward, as we've talked about witness intimidation, we want to identify all those forms of intimidation, the overt ones, the subtle ones, ones that defendants know are going to impact victims such that they will be either afraid to come to court or afraid to call the police, whatever it is. We need to identify those. And then we need to proactively investigate the intimidation as it's occurring. That evidence, particularly if it's working, if the intimidation is working, may not fall in our lap. So we definitely want to ask about intimidation. And you're probably not just going to ask, hey, is the defendant doing anything to intimidate you? But just ask questions about, is anybody doing anything, talking to you about this case? Are they making you feel like you shouldn't come to court or making it difficult for you? Are you afraid? Things like that. And then we want to find out who's making those threats, what those threats are, and do anything we can to make that victim safe, improve that victim's safety. We want to introduce the admissible victim statements that may come in because they're non-testimonial hearsay, and there's a hearsay exception. So we want to identify those statements that they've made to others about the crime so that we can introduce those. And then forfeiture by wrongdoing, it's not going to work in every case, but it probably will work in some cases we've all had, or we've all seen that there might have been a way to get this evidence in if we had done a forfeiture by wrongdoing motion. So let's try and think about these things moving forward, and we're happy to help people in any way we can to get these things done. We've got some additional resources here that are available on the Equitas website. So we have a combating witness intimidation experience in creating change. We have a field guide to witness intimidation. So it talks about the different types of intimidation, the crimes associated with it, the tactics that they'll use, things like that. Also the unintended intimidation that maybe comes from police, prosecutors, the courts, because we're just doing our jobs. If the more trauma informed we are, the better we'll do those jobs, and we won't inadvertently intimidate people and make them feel like they're too afraid to participate in the system. There's a webinar we have, Enhancing Witness Safety, Preventing and Responding Intimidation, Preventing and Responding to Intimidation, and then the Principles of Witness Intimidation webinar that we have. We also have some publications. This one's on forfeiture by wrongdoing, legal jujitsu, which is the sort of martial art that allows you to use the assailant's force against them. So it's legal jujitsu for prosecutors in intimate partner violence cases, forfeiture by wrongdoing. And then another one, No Victim, Don't Give Up, Creative Strategies on Prosecuting Human Trafficking Cases Using Forfeiture by Wrongdoing and Other Evidence-Based Techniques, and the prosecutor's resource on forfeiture by wrongdoing, which is a very straightforward, simple resource. This is Jane's contact information, and you guys will get this in the materials when they are sent out. That's my contact information, which will be in those materials as well. And this is just an ad for our office hours, which is just for prosecutors. I think the next one is on January 20th. You guys can find it on our website if you care to engage in a conversation of prosecutors with prosecutors. The topic this January 20th is stalking. And so it's unrecorded, small presentation, and then a good conversation with prosecutors about this. Okay.